All right, so we'll get things rolling. I appreciate everybody making the time to join us today. I've been wanting to put something like this together for a while, and the circumstances just didn't present themselves until recently. So I'm glad that we were able to do this. Matt, I'm going to turn this over to you. Matt Burr is a friend of mine, a colleague that we've been connected fairly recently. He is an HR consultant with a number of years of experience. And with that, Matt, I'm going to let you take it from here and do a better job of introducing yourself and talking about the topics for today.
Yeah, no, appreciate that. So thank you very much. And again, anyone that has a question, feel free to interrupt me, unmute yourself, or if it's easier to send it through the chat box, whatever works for you. I'm happy to field these questions and, get anything answered that I can on the call. I mean, again, I think specifically related to unemployment and calling employees back to work, I think we're going to see some evolution, unfortunately, on that area, but we'll see what happens. The same with the New York State paid sick leave that's coming at us in 2021. I'm kind of waiting to see what happens from the state side as well, related specifically to considerations around PTO and vacation time that's already being offered, or any sick time that we're already offering. So again, what I've got is more high level on the sick leave stuff, but it's something just to be aware of for your organizations, because it's really driven by New York City initiative. And you can research New York City paid sick leave, and it's going to pop up all the information, basically cookie cut to what we're going to be held to across the state. I mean, the same, PFL was driven by that as well. So just some things to be aware of. Couple of quick changes as well, just for folks on the call to understand. The voting law just got changed back to the pre-2019 legislation. Actually, Ed, we should make a note of that. We need to change that in your handbook as well, since we just redid your handbook. So that's one we need to actually modify. So that's back to the unpaid voting leave or voting laws that were in place before 2019. So people, just be aware of that one. And then from the I-9 perspective, if you are hiring people, you can do all that stuff remotely through Zoom right now. That one, again, some laws just changed on that at the end of last week as well. And I'm happy to share an article I just wrote on that on Monday. That just populated, I think, about 7:30 this morning. So, Ed, feel free to send that out to people if you wanted to as well, so they can see kind of what that I-9 legislation looked like. So, all right. So again, kind of what we're talking about here. The unemployment, calling people back to work would be good. Those are things right there as well that we're going to talk about. And then the paid sick leave and compliance audits is another thing. So, and we're going to go through, Ed was nice enough to let me kind of pull up his compliance audit Word document and just kind of work through that line by line. He did well. I mean, and again, I think part of my job is to come in and be that, nitpicky HR person to make sure that we correct it before the government steps in and makes you correct it with fines and all kinds of things. So we'll talk about that and just some common mistakes I see really all the time when I do these audits. So quick background on me, real quickly here. Just quickly, I've been in HR, I think, roughly since 2006. So just about 14 years I've been in the field. Started out as an intern when I was an undergrad at MHRIR College. Worked myself up to a director role, interim director role at Kennedy Valve Manufacturing, at Guthrie. I started at Kennedy Valve as an intern and worked my way up to interim director at Guthrie, the new Corning Hospital. And then decided really about 5 years ago, last month or in March, to really start doing the consulting thing and kind of really got it going in October 2015 after thinking about it for a few months, reading on it, and have been growing it ever since. And so, again, I support roughly 40 to 50 organizations in the Southern tier. I've got some clients in New York City and done some work outside of the country and in other states as well, but mainly centered here. A lot of clients in Ithaca and, Corning, Elmira, Watkins Glen. So really quite a dynamic group, an interesting group of clients in a variety of industries. So dealing with the things we're going to talk about today: unemployment, compliance, workplace investigations, the legal side, job descriptions, employee handbooks, all the things that that you worry about with HR as well. specifically around those areas. You know, performance improvements. You know, any of those things I've done. I filled in as a director in certain, you know, organizations a couple times when people were out on maternity leave. I've gone in and done some change management where I've managed some HR people out and replaced some of those positions. I've done that a few times, and that's been a successful process as well. So, and again, you can see from my background academically, TC3 all the way down to Syracuse, where I've gotten my MBA a couple years ago. Working on another degree through Tulane. It's a master's degree in jurisprudence, labor and employment law, because my consulting has gotten so technical on the legal side with accommodations and now with the coronavirus, you know, the legislation on that, really technical areas of legal that I've got to understand and know. And frankly, the legal side of HR has always been my strongest area as well. So we could have a conversation, back to Ed's point, about managing finances and all that fun stuff. I could talk to you probably for 3 or 4 hours about student loan debt. That's another area that I'm a professional at understanding, professional as well on the student loan debt. So we could talk about that. But we'll go ahead and continue on here. As we get into this, maybe you've got some other questions about my background, that's fine. And some of you might have already worked with, we've made contact with at some point as well. So, all right, so kind of the agenda today, we're going to talk about the unemployment insurance. I know Ed's got a couple things he wanted to talk about related to COBRA and related to insurance as you kind of furlough people, lay people off versus furlough. So I'm going to have him jump in at some point during this conversation as well. Questions to answer, you know, work share options, fighting unemployment, and then I'm going to have, you know, a conversation on kind of upcoming paid sick leave as well. I think I've got some other things in here, and we'll talk about the audits in a separate document, and so I'll bring that up when we get to it as well during this conversation. So, all right, so just so people understand, and I'm assuming everyone on the call knows this at this point, but just wanted to make, you know, everyone aware of it, you know, and it's become a pretty hot topic, in my opinion, the last couple of weeks, related to the you know, the $600, I call it the federal kicker for unemployment. It's quite an incentive to not go to work. And again, I think if you probably saw in New York State over the weekend, Governor Cuomo extended, I believe, until June 6th, the stay-at-home order across the state. And again, I think this expires, I believe, at the end of July, this additional $600. So again, federal government has allowed states to change their unemployment benefit laws. It lets them provide unemployment benefits for situations related to coronavirus. I think we all know that. Under the Corona Aid, Relief, and Economic Security, the CARES Act, again, it's expanded benefits further. Self-employed workers and gig workers to receive unemployment benefits. I've talked to a couple people that do the consulting, the 1099. It's not as easy as I think that they're making it look on this slide, or this came right off the federal government website. Not as easy to get that. I've heard some frustrations and some you know, issues related to that with the self-employed, but more so for your group, all unemployed workers are going to receive an extra $600 a week for up to 6 months, right? So that's become an issue, a contentious issue with employers trying to get people back to work, or frankly, keep people employed that might be defined as the essential workers in this area and across the country. So I've heard it. You know, I was just on a call with folks, HR professionals from across the state, volunteers from across the state. We're all dealing with the same issue related to that $600 additional per week, and plus the $400 or $500 you might get on top of that. So you're talking $1,100, $1,200 a week to be on unemployment. That's, you know, in my opinion, that's not bad money. So again, unemployed workers, you're going to get the additional 13 weeks of benefits beyond a number that the state currently provides. So I think everyone's aware of that. So again, just the eligibility, just so people understand this, unemployment insurance programs pay money if you lose your job through no fault of your own. Again, as we're reaching a 40 million person unemployment number, that's quite a few people now applying for unemployment. That doesn't mean that if we call someone back to work that we can't fight these unemployment claims. In fact, I encourage any employer to fight unemployment claims as people are not coming back to work. There's other options like shared work and things like that that can help phase people back into the the workforce. But, again, if you've got work for people to do and they say, I'd rather be at home on unemployment, that's really not a legal claim unless there's an issue with coronavirus. And we'll talk about that in just a second as well. And again, we've already talked about some of these things, anything you need to know. How do you apply? I think everyone understands that there's been a bunch of bottlenecks with the unemployment system. My understanding is a lot of recent unemployment claims have been put on hold as well related to that. So another thing about my background, I didn't get into too much. I was just too excited to get into the slides. Again, I teach full-time at Elmira College right now, so I'm a business management professor over there. And I've got 6-week classes going, teaching effective negotiations to 19 students through Zoom, which is quite a challenge right now to use Zoom to try to effectively negotiate contracts, right? Not an easy thing to do. It's an interesting process. So, all right. So again, just some other things to think about here. You might be eligible for benefits, again, if you meet some of the circumstances listed. So these are the things I kind of wanted to get into. I apologize for the words on the slides. And it's not because I want to read all this stuff to you. It's because I want you to have this detailed information when we hand out these slides. So you've got it, you understand it, you know kind of what the process looks like in case you do have to fight a claim or in case you do have to do something else with it and when you're trying to come back to work. So again, so here we go. My employers remained open because it's essential. I'm not sick, nor is anyone in my household sick. I do not have children or care for someone who cannot take care of themselves. However, I'm afraid of getting coronavirus from customers coming to the store. So again, or to the workplace, let's say. So I quit and filed for unemployment. Can I obtain benefits under the CARE Act? And so again, the government's answer is no. Obviously, that would be one we might have to fight in this state if we do come up with an issue. So the one thing I wanted to call your attention to on this slide is kind of the second and third paragraph here. There are circumstances under the CARES Act in which specific credible health concerns could require an individual to quit his or her job and thereby make the individual eligible, let's just call it for unemployment across the board. Here we go. For example, an individual may be eligible for unemployment if he or she was diagnosed with COVID-19 by a qualified medical professional. I support the hotel industry as well, a number of hotels across this area. I've got people self-diagnosing that they need to take, that they need to be in quarantine till the end of June. And I said, that doesn't make any sense at all. It's a self-quarantine, not even diagnosed by a physician. I said, I want to see that in writing before I'm getting any type of self-diagnosis that they need to be in self-quarantine till the end of June. I believe it's a 14-day period, not 6 or 7 weeks collecting that extra money. So I've had that conversation as well. We've had people self-diagnose. I can't come back to work till July. Probably not the best situation for them to be in, trying to make that and I said, I want to see it in writing from a physician that they need to be in a self-quarantine at this point. And not saying that physicians won't pencil whip a note about that, but I'm not going to accept a self-diagnosis either at that point when it's related to stuff like this. So let's see, medical professional, although an individual no longer has COVID-19, the illness caused health complications that render the individual objectively unable to perform his or her essential functions with or without reasonable accommodation. So we've got that ADA stuff in there as well. And again, and this is the kicker here that you've got to kind of hang your hat on if you're the employer. And again, I'm not saying every employee is out to take advantage and get that extra money. But in what I've dealt with recently, I've had more cases than not about some of these things being almost like I don't want to come to work because I want to collect unemployment. So voluntarily deciding to quit your job out of a general concern about exposure to COVID-19 does not make you eligible. If you believe your employer's response to the possible spread of COVID-19 creates a serious safety hazard or an OSHA issue, you can file a complaint. So again, in my opinion, we've got to be much more proactive in providing the correct PPE, training, our employees coming back to work to ensure that they don't feel there is an issue at this point related to coming back, or if they're an essential worker, where they do quit voluntarily, saying like it's a constructive discharge, that you're creating a hostile work environment or retaliation or whatever else might happen. If they just don't want to work because they don't want to work, that to me is unacceptable. And that to me is worth at least going to the unemployment hearing and trying to fight, because it's not supposed to be allowed, in this situation. So, as a general matter, you're likely to be eligible for the benefit due to concerns about exposure to coronavirus only if you've been advised by a healthcare provider to self-quarantine. That's what I said. Show me in writing. I'm not going to accept a self-diagnosis. For instance, an individual whose immune system, again, compromised. So you can see all those things. And again, I'm all about and safety and health always, welfare of everybody. But, if they're just saying, I don't want to come to work because I don't want to come to work, that's an issue for me. And that's where I would absolutely encourage people to fight some of these things as well. So, and one thing you want to be aware of with that is the New York State just put out a website on coronavirus discrimination and creating a hostile work environment. There's a posting out there. Not sure if it's required or not required at this point. It's almost like an ADA coronavirus New York State posting. Happy to send that out. I read that on Friday afternoon. I can definitely send that link out to Ed when we distribute this information as well. But it's just something to be aware of, where they're making it very easy for employees to file claims potentially against an organization. So just be aware that that poster might be legal or required. I'm not sure yet. The paid sick leave in New York State wasn't a required posting. It was recommended. So that's something I still want to get clarification on, whether we have to do it or not. So, all right. Was there a question, Ed? I saw the thing blinking. Do I need to answer anything, or?
No, we don't have any specific questions yet, but I will throw this into there as a question. So if you do want to have either an employee come back to work, or in a case like mine, all of my employees are working from home, but it's preferable for certain employees to be in the office. If an employee gives you much pushback about coming back to the office, is this really where this sort of a discussion comes into play, where you got to be able to show we're following all the guidelines, we're going to provide the PPE, and if there's any pushback on that, minus a letter from a medical professional to say, your employee has a condition whereby we want them to work from home. Is that what you're saying, is that it's really important to cover all these bases?
Yeah. So that's an interesting situation, because again, now that we have all these people working remotely, and it's the same for me now. I could go back to let's say the college opens back up. We're going to go back to live classes in September. I mean, that's my hope. I do miss, being in front of the group of students, but if I was concerned about being around, a group of 25, 30 students for, in each of my 3 classes next fall, and say, hey, I need an accommodation to work from home and do Zoom classes forever now, they might have to actually say, yeah, that's a reasonable accommodation under the ADA and under New York State law. That could be a potential solution presented. Now it's up to you or to me as the organization and the employer. So let's say that happens with one of your employees that says, I want to work from home now forever. I don't want to come back in, at least, for until we get some type of, whatever, to fix the coronavirus. I forget the name I'm thinking of, but anyway, immunity, I guess. So they say, I want to work from home now. It's up to us to determine if that's a reasonable accommodation, right? But if we've already let them work from home with no issue, you might have a hard time making an argument that it isn't a reasonable accommodation anymore. So that's an ADA. I mean, that's absolutely can be the case. Other states have already put in ADA type language, state of Washington, around some of those things. So that's that's going to be a case by case basis for every organization to take a look at. And if we say no, we've got to have justification on why that person can't work from home. If it's the front desk secretary that's greeting people every day and we've provided the PPE and all those things, you know, I mean, I could probably deny something like that and say, no, we need somebody there to you know, field stuff, people walking in, we've provided everything. So, but yeah, that's a case by case situation. So good question.
And there is one other question asking about what's the best way to get these posters.
Yeah, so the posters, so, you know, ironically, and I didn't mention this, is the poster behind me, I actually own a printing company to print labor and employment law posters. Some of these one-off posters, like the federal government had the paid coronavirus sick leave, the New York State coronavirus sick leave, the one I just told you about, I'm happy to send those links. New York State's got if you looked up New York State labor and employment law posters, just type that into Google or any type of search engine. Normally, it's going to populate a website, a DOL website that takes you to all the required or recommended posters out there. And I can send all that stuff over to Ed after we get off this call. But yeah, I mean, if you've got specific questions on posters, happy to answer those, because that's another area that I find when I audit, you know, people have issues on as well, is making sure we have up-to-date posters, non-expired stuff. So yeah, I can definitely get you more information on that one. So, so yeah, great question. All right, so I was furloughed by my employer, but they have now reopened and asked me to return to my job. Can I remain on unemployment? This is another fun one right here. So here we go. As a general matter, individuals receiving regular unemployment comp must act upon any referral to suitable employment and must act on any offer of suitable employment, barring unusual circumstances. So I would say laid off or furloughed, or requested a furloughed employee return to his or her job very likely constitutes an offer of employment. While eligibility for unemployment does not turn on whether an individual is actively seeking work, it does require the individual be unemployed partially. So the short answer to this is, if we're offering somebody a chance to return to work, if you've got somebody temporarily furloughed or you've got somebody laid off, you know, forever, however long the state might be shut down, and you say, hey, we're ready to open back up, or we're going to do a phased-in approach, they cannot turn that down. You know, well, they can turn it down, but that's another way you could fight unemployment. I just did this presentation 2 weeks ago for the Watkins Glen Chamber of Commerce, because there's been so many issues, you know, in the restaurants and the hotels and things like that, where people are having an issue bringing people back or wanting them to come back to work, probably from fear from the coronavirus for sure. But if we're offering them employment at that point, suitable employment, and they say no, that to me is another way to fight the unemployment claim right there, and have that, you know, case in front of the, you know, administrative law judge or the unemployment judge, whether it's on the phone or in person, probably more likely on the phone or a Zoom conference. But yeah, I mean, they can't turn that down. And I would encourage people, if you are having these conversations, if you do have people on furlough or laid off at this point, when you are calling them back, I would put it in writing and send a certified letter to their house saying, you know, this is the expectation. You come back to work on this date, you know, the offer, the job, the title, whatever, how many hours. I mean, kind of make it like an offer letter. It's a return to work offer letter. And if they turn it down, you've got it in writing, you send it to them, certified mail, and that's just another way to present that information in case you do have to end up in an unemployment hearing over that situation. Hopefully you don't, but again, it's me, you know, really stacking the deck in your favor in case there is an issue where people want to collect that unemployment, you know, as long as possible. And again, another thing you can do is just remind people that extra money for unemployment does supposedly end at the end of July. Not saying they couldn't, you know, extend that, but that $600 bonus is going to end at some point. So you got to, you know, again, there might be a way to phase people back in as well. So, all right. One of my workers quit because he said he would prefer to receive the unemployment comp benefits under the CARES Act. I've heard this one too. So the answer to that is the same thing I've been telling you. You can't just have people quit because they're, you know, because they want to receive that unemployment. Now, again, if there's issues related to health and safety, if there's some type of, you know, hostile work environment, whatever that might look like, that could be an issue as well. But if we're providing all the PPE and all the things necessary related to unemployment, or excuse me, related to employment and bringing people back and keeping people on as essential workers, we do have a claim there to fight as well. So no, you can't, just because they want to collect unemployment doesn't mean they're going to be eligible for it. And I know at times unemployment hearings are an uphill battle in New York. I've had some good wins lately, and I've had some losses lately, not related to the coronavirus specifically or furloughs or layoffs because of this, but other issues with other organizations prior to prior to the pandemic. So the answer is no. Just because they want to collect does not mean they're going to be eligible to collect unemployment. It's just not going to happen, and it's another one we got to fight at that point. So. All right, so shared work. Wanted to talk a little bit about shared work. Some of you might be familiar with this, and I'm happy to share a contact with anyone on the call for a local person that sits in Elmira, New York, that is working for the DOL and kind of manages this program. So basically, shared work is kind of a phased work approach where you might have somebody working 1 or 2 days a week or 3 days a week and collecting unemployment for the other 2 days. I guess the benefit to the shared work program is we are keeping people actively engaged and avoiding a full-time layoff. And the benefit to the employee is, again, they're able to keep their job, maybe keep their benefits going, maybe some type of retirement program as well if you're doing a match at this point. But they're also able to collect unemployment. Even if they're laid off for just 1 day or 2 days, they are eligible for the $600 bonus. I'll call it the federal unemployment bonus at this point. I hate to define it as a bonus because it really isn't, but they do get the $600 from the federal government. I'll give you an example real quickly. One of the guys I used to work with in Michigan at the paper mill, he drives for a local auto parts company. He was laid off. He was only working about 15 hours a week. He's retired. But he was able to file for unemployment, off the 15 hours he averaged per week, and he got this $600 kicker. So he's getting quite a lot of money per week on unemployment, even though he was only working part-time. So, and he was even complaining about the 600. So anyway, that's kind of what this looks like. Again, it gives you the flexibility to retain people. And it gives you the flexibility to have people maybe do a phased back-in approach to working full-time, whatever that might look like. Maybe you need people coming back full-time. Maybe you're not ready to ramp up full-time yet. That's kind of what that work share program looks like. There's documents. All these things take you to those links as well, kind of a fact sheet, what employees need to do when they're filing for unemployment. That's the type of stuff there. So, again, and that would kind of, this can be done even after you've submitted a WARN Act notice. And I can talk you through a little bit on WARN Act here in just a minute as well. So, okay. So here's your information. I forgot I added it to the slide. So you've got how to file for unemployment, rapid responses for business customers, the shared work fact sheet, and then Lisa Dolan as well. She would be the local representative for the Department of Labor. And she's the one that shared all this information with me as well related to work share and how that whole process works. It's a relatively easy, shared work process. It's a relatively easy program to implement. I used it probably 10 or 12 years ago when I worked up in Bath, New York, and we had to lay people off based on, kind of a contract and things like that, or furlough people. So that's kind of what that process looks like. So wanted to let Ed jump in real quick and talk about maybe the difference between furlough and layoff related to benefits and retirement and all that stuff. So I'll let you jump in if you wanted to add anything here real quick.
Sure. So the question that we get in our office fairly often from employers is, I've got this situation and need to let people go. And in this case, it's all been about COVID-19 and the quarantine and the shutdown. So I get the question from time to time about, well, what's the difference between furloughing and just laying people off? Well, the big difference is that with a layoff, you're terminating employment completely. So the employee, outside of any type of a severance agreement that you might have, is going to lose access to all of their employee benefits. So whether it's medical insurance right down through the flex spending account, to their group life and disability insurance that you might have in force for them as an employee, they lose access to that when they're laid off. They get any of the appropriate COBRA notices that need to go out, and they have to just take it from there. A furlough is a little bit different in that while an employee is being furloughed, you can keep them on their employee benefits. Some employers use this as an option just so that people can stay on their health insurance, because that's always the biggest challenge, is can they afford to go to either COBRA or to the marketplace? It all really depends on the situation. For the most part in our office, what we've been seeing is layoffs. We have really not seen an awful lot in the furlough area, although I have had a handful of groups put together what I have called, and Matt will chime in on this, I've called them ad hoc furlough arrangements, where employers have basically said, look, we're going to keep you on the health insurance for another month or so, but you can go file for unemployment because we're going to have to let you go. And if things change, they can switch them back, very, very, very easily. But those are the real big differences. Matt alluded to, matching contributions for retirement plans. It's all of those benefits that are wrapped up and are sacrificed when a person is terminated versus furloughed. So, again, if anybody has any questions on that, certainly, feel free to use the chat box, and we'll plug them in as we go.
Yeah, I mean, it's basically furloughs like it's a temporary layoff, but like you said, it's trying to keep everything intact, so it isn't going through like an enrollment process again and all the steps to get them back going again. And frankly, again, to kind of keep that, it's that engagement piece as well. So I much rather prefer a furlough than a layoff. I mean, I've been in both situations. Unfortunately, had to manage through both situations, and furlough is the best thing with the shared work program, if possible, would be the direction I would encourage any organization to utilize if you haven't already. But as you're bringing people back to work, there might be opportunity to phase them in the 1, 2, or 3 days a week until they're back to full time, whatever that might look like. That's really up to every organization specific, really, case by case. But again, happy to answer any questions on that as well. So. All right, so just quickly about the WARN Act, just so people understand the differences. New York State, and I think Rhode Island's the other state that has another kind of a mini WARN is what they call it. You can see the differences if we're going to, to have a mass layoff, within an organization. Obviously, if you took the PPP loan, you've got the 8 weeks of pay for people as well. So, but you can see the differences. It was 100 or more employees versus 50, 60 days versus 90. And again, you can see kind of those differences as we go down, around some of these things as well. I think New Jersey actually, they waived this because of the coronavirus, but they had a law in place starting this year, I believe in January, that if you were going to have a massive layoff, you owed everybody 2 weeks of severance pay. So that's a new law. That's something that I've seen in Europe, and I think Canada offers very similar or has very similar legislation. But yeah, so New Jersey was actually making companies pay 2 weeks of severance on top of any type of accrued PTO or vacation. They waived it because of this, at least, made an exception for now. I wouldn't be surprised if we see something very similar to that at some point in New York State, where if we do have a layoff and it triggers an event like this, that we are going to have to owe everybody severance. Normally in a severance situation, it's more of your salaried white collar, exempt people versus your non-exempt hourly people when we're talking about severance. So anyway, that's kind of what the WARN Act looks like at this point. The link's out there for you to take a look at. You can compare, federal versus state. Again, in any situation, the more pro-employee the law is, that's the law we follow from an HR standpoint. So, again, another example, federal minimum wage is $7.25 in this state. For your non-restaurant workers, I believe what is it, $11.80 or something, $12.50 right now. I forget, one of those two. We don't follow the 725 rule. We follow the one that's the higher, just like the exempt, non-exempt on the administrative and executive exemptions there as well. It's higher in New York State than it is federally. So, all right. Just a couple other links there for you to take a look at. Again, a lot of the Q&A stuff I had on this presentation came right off the Department of Labor, the federal website, not the state one, but there is additional links out there to review if you've got any specific questions. Look, and if you need help fighting an unemployment claim, if you have issues or have questions on unemployment, I've written many letters for organizations when we're trying to fight some of these unemployment claims or having conversations about what the path forward might look like. Absolutely happy to have that conversation with anyone on the call, making sure, again, we're doing the right thing for the employee, for your workforce, building the culture you want, but also making sure your organization is going to be sustainable for the long term as well, because we do want to get people back to work as soon as we possibly can. And I think most people, if not everyone, would agree with that statement that we do want to get people back into the workplace. It's just how do we do that is the question I think everyone's trying to answer right now. So. All right, so next on the docket here, wanted to again just share some of the paid sick leave stuff with people on the call as well. So in April 2020, New York State passed a law requiring any employer to provide sick leave to employees. The legislation becomes effective 100 days after it was enacted, with a tentative start date of required leave in September 2020. Really, it's not going to be effective until 2021, but the law will be live in September 20. I think it's September 28th or 29th is when that law will be effective in this state. So just want to continue to watch for. If I'm going to compare it to anything, probably something like the paid family leave. This is going to be one of those legal requirements and making sure we're communicating it. Again, if we're looking at it from the New York City perspective, New York City employers are required to have a poster about paid sick leave. So it's probably going to be required across the state as well. I haven't seen any specific poster related to this yet, but don't be surprised if we were going to be hanging up another poster or, on the combined poster like this, where there's a section carved out for New York State paid sick leave, because in New York City, it's required to have that up in every organization. So, all right, so sick leave, and employers required to provide, and whether the sick leave is to be paid or unpaid depends on the size of the employer. So here we go. Employers with four or fewer employees with a net income of $1 million or less in the prior tax year must provide employees with up to 40 hours of unpaid sick leave in each calendar year. So there's 5 days right there. If you're working 8-hour days of unpaid sick leave. So four or fewer, I don't know why I keep saying that, unpaid 40 hours of unpaid sick leave. So here we go. 4 or fewer employees with a net income of greater than $1 million. So you're doing really well. Here we go. Must provide employees with up to 40 hours of paid sick leave in each calendar year. So there you go. There's your difference in a negative $1 million or positive $1 million. You're going to have to be paid or unpaid at this point. Employers with between 5 and 99 employees must provide up to 40 hours of paid sick leave in each calendar year, right? So there we go. Definitely paid there. 100 or more employees must provide up to 56 hours of paid sick leave in each calendar year, right? So there we go. Here's your accrual. Employees accrue leave at a rate of not less than 1 hour for every 30 hours worked. Employees begin to accrue sick leave when the law goes into effect or upon the employee's date of hire, whichever is later. So September 30th, they would begin accruing basically for 2021 at this point under the state law. I don't see now, again, if we're thinking about paid family leave, I think we're at 10 weeks now, and it's at 60 or 50, whatever, for 60% right now, and it jumps to 12 to 67%. I haven't seen anything specific on any type of phase in where it's going to get more. They get more sick leave. That's just not going to happen, at least from what I've read on this law. I think it's to be determined on how this thing is going to shake out as well. But this is kind of what the law looks like at this point. So. I see we got some stuff coming in here. What do we have?
Yeah, so we've got a couple of questions. Does this leave have to be titled sick leave, or can it be incorporated as part of PTO?
Yeah, so, go ahead. Throw me another.
And then tying that into this, same question was asked by a couple of different folks. Is this for both full-time and part-time employees, or just for full-time people?
Yes, so I believe it's for both full-time and part-time. The PTO thing, I'm still waiting to see kind of how the state is doing that. It sounds like if you're doing more than what they're asking for, like if you're giving people more than 40 hours now, you don't have to add another 40 hours into the bank at this point. I'm still kind of seeing how the state clarifies that. I would say to be determined. Probably more than likely, if you're already giving something like a PTO bank with some time off, you should be okay. But I want to wait and see how the state answers that question as we get closer to September. But yes, it does impact both full and part-time employees, and it's kind of that accrual. And the accrual, I think, is going to be broken down in a calculation like a frequently asked questions tab on one of the New York State websites. So great questions, and it's one that I'm going to say just wait and see kind of how the state answers those questions. I mean, again, I think if you want to look at anything specific, feel free to take a look at like New York City paid sick leave. That kind of answers how we're probably going to be how it's going to be phased in across the state. Unfortunately, whatever New York City does starts to impact the rest of New York State as well, and it does impact, I believe, both full-time and part-time in New York City. So
Matt, this was a follow-up clarifying question. When does this take effect?
Right here. Although employees may begin accruing leave prior to January 2021, employers are not required to begin to allow employees to take sick leave under the statute until January 1st, 2021. Now look, I'm going to say right now it's a tentative start date of January 1st, 2021. However, if we have more issues with the coronavirus and there's a slower start to the economy, whatever that might look like, this date can be fluid as well. They might push it out 6 months. They're not going to bring it in any closer than January 1st, 2021, but the start date, the effective date of this law, when they are able to take sick days or PTO days, whatever you're going to call it, would be January 1st, 2021. So that's kind of what this looks like right now. But again, yet to be determined. Kind of watch for any changes on this. I think they're so focused on on the pandemic and getting that under control. This is probably taking a back seat. But don't wait until December 31st to look at the laws on this either and realize, oh my gosh, I got to take care of this. It starts January 1st. Start looking at it, in the summer, towards the end of the summer, fall. Make sure you're staying on top of it, updating any policies, hanging up any postings that might be required, and again, communicating to employees as well. Good questions. I mean, again, this is so new, even for me. It's a newer one, but I've somewhat worked with the New York City stuff as well. So, all right.
So I'm going to jump in there one more time, just as a bit of a shameless plug back to you, and that is to say that when it comes to creating these kinds of policies, I mean, looking at the folks that we've got on the call here, almost all of my clients are businesses and organizations like the ones that are on the call. These are small organizations. There's a couple in here that are the outliers, being a little bit larger, but for the most part, 10 employees or less. So the function of creating these kind of policies has got to fall to somebody. And for everybody on the call, this is why I wanted to have Matt talk to everybody. You need to have access to somebody like him that you can say, okay, what is it that we need to do? How do we build these policies and procedures, build them into the handbook, build them into the communications that we have with our folks? Because ultimately, and this applies to me too as an employer, we're the ones that are responsible. We're the ones that ultimately have to face any problems for either not offering appropriate programs like this or doing them incorrectly. So just to push that back out there, as this information starts to evolve, make sure that for those of you that want to reach out to Matt directly when you get his contact information and work through these processes. It was a very valuable thing for me to do in my office. So that's all I wanted to push out there on that.
Yeah, thank you. Yeah, I didn't want to push the plug too much, but I'll let you jump in and take care of it for me. So yeah, thank you. Anyway, let's keep going here so you can keep moving. No, I appreciate that. And yeah, I'm happy to work with any organization. I've worked with companies from hiring the first employee, from becoming like more of a contractor to the first employee hired. I've got clients that have 260 employees in manufacturing. So I work across the board with many organizations, probably support roughly 2,000 employees from an HR consulting standpoint. So Employers must set a reasonable minimum increment for the use of sick leave, but may not exceed 4 hours. So if you remember, under paid family leave, intermittent leave is 1 day. Obviously, the 4-hour thing is potentially on the table now. This is interesting here as well. Unused sick leave may be carried over by employees to the following calendar year, but employers with fewer than 100 employees may limit the use of sick leave to 40 hours per calendar year, and employers with 100 or more employees may limit the use of sick leave to 56 hours per calendar year. So employers are, and this is a good one to know, I'm sure this could have come up in a question, not required to pay employees for unused sick leave upon separation from employment. That would be something you want to put in a policy, that statement right there. We're not going to pay people unused accrued sick leave, or if you pay people PTO, you probably want to put a cap on those things, whether you pay full-time or part-time employees. That's the type of thing you want to add in a policy. What does your call-in process look like? And I say this because this has been in many court cases I've done research on recently. So you want to have something to clarify. Are we going to accept a text message from an employee? Are we going to accept a phone call from an employee, an email? What if somebody says, I'm going to use sick leave on Facebook Messenger to a supervisor or to the business owner like Ed? Is that acceptable workplace communication? It depends on what you want to use. What if they send a fax? I mean, again, I just rewrote a policy around communication, around sick leave and PFL and using some of these FMLA. Really up to you, but that's something you want to have spelled out in detail, because if it's not, and you say we're not, and you terminate somebody for sending a text message about using paid sick leave, probably not going to go in your favor at that point, because it's a standard way people do communicate in the world now. Those are things you got to be real careful if we're talking about communication around these policies as well. So, all right.
One last question on that. What about seasonal temporary workers?
Yeah, so that one, I'm going to hold off until I do a little more research on that. I'm assuming that it would be very similar to accruals like paid family leave. You have to work 175 days or whatever that might look like. So I'll take a note of that one and write that down. I might have answered that later on in this presentation, but if not, I can get back to you on that one. So that one I'm not sure of. I don't think so, but I will double check that. Sick leave. All right. So when can sick leave be?
One more jump in on that. So a question that came in is, can you comment on having employees use FMLA right now, matching their salary in order to keep employees employed currently?
So I'm assuming they're talking about the coronavirus sick leave, or?
Just looking at the question in the chat box, maybe you can read that and get a better idea.
Can you comment on having employees use FMLA right now and matching their salary in order to keep the employees employed during these times, matching the remaining 1/3? Yeah, I mean, if they qualify for that FMLA, that the coronavirus paid federal sick leave, I mean, again, it's up to you and your policy if you're going to match that or not. Give them the option. That I think it's an optional thing for the employer to do, but they do have to qualify for it, for that paid federal sick leave. That is something that, I mean, again, it's totally up to you. I mean, just make sure that they are qualifying for that paid FMLA. Again, I've had employers that have been exempted from that leave because they're an essential business, and I've had to deny employees the paid FMLA at this point. So I've had kind of the opposite experience of what Kathleen is asking at this point. So, I might maybe we have a side conversation after this to understand maybe more of kind of what your question is on that one, just to make sure I'm understanding it. But yeah, I'm happy to answer anything on that one. So let's see, what else do we have here? When can sick leave be taken? Again, just some things here: mental or physical illness, condition, health condition of employee, family member, regardless of whether the illness, injury diagnosed or not. Again, you can kind of see some of these areas where you can use sick leave. Again, those are things we're going to want information on and document some of this stuff as well. But I'm not going to jump into everything. These slides are out there for you to take a look at. So. Domestic violence, again, some of these things: safety planning, permanently relocate to other actions. meet with an attorney or social services, file a complaint or domestic incident, district attorney, take any other actions necessary to ensure the health and safety of the employer or the employee's family member, right? So those are some areas where they can use the New York State sick leave, if when it comes into play. Then just some definitions here, from a family member standpoint, just so people understand. Again, this is broader than the federal definition of a family member per FMLA, Department of Labor at the federal level. A child, spouse, domestic partner. Domestic partner is not included in the FMLA specifically at the federal level. Sibling, again, not included in FMLA or PFL yet. I'm going to say yet on that one because I think when they expand paid family leave, it's going to include a brother or sister. So keep an eye on that as well. That could be included now in paid family leave as they're going to push it through the sick leave here. Grandchild and grandparent not included in federal FMLA. And then again, child or parent of the employee's spouse or domestic partner. Employees may not require an employee to disclose confidential. So here you go. Employers may not require an employee to disclose confidential information related to the reasons for the use of sick leave. That puts us in a kind of a disadvantage to manage that process. So employers that have adopted a sick leave policy or PTO policy that provides employees with an amount of leave which meets or exceeds the amount required by the statute and satisfies the accrual, carryover, and use requirements of the statute is not obligated to provide any additional sick leave. So again, that answers it to an extent, but I just want to make sure before we get into anything related to what you're already offering, PTO, carryover, the accrual process, wait and see kind of what the state comes out with related to that specifically. I mean, I think most people on the call are probably offering things like this, but just be aware that's kind of what it's looking like right now. So, and then just some other considerations, posters, policy, we talked about that, handbook updating, how it interacts with what your PTO and vacation stuff might be now. With the PFL, we got to train managers and supervisors. Really what we need to focus on with employees, managers, and supervisors is potential retaliation issues if we do have somebody using the sick leave. Legally, they're allowed to use it. Legally, they can use it for anything. Legally, we can't even require what they're using it for or try to track it down. That can cause some issues at your middle management level at times related to PFL, related to sick leave, related to FMLA. Those are the things that we do have to kind of keep an eye on as leaders and business owners and organizations to ensure none of those things happen. And then I can tell you, retaliation under EEOC laws, EEOC retaliation is the #1 issue that employers are getting sued on right now. It used to be race. Retaliation has taken the top level because we're not only do they have a claim against us, we go ahead and now we do something even dumber and retaliate against the person, and now they've got a second claim against us. Or we fired them for filing a sexual harassment claim internally. We don't want to deal with it, so you're no longer employed here. Now they file for retaliation. So we got to be careful of those things as well. Communicating, making sure our payroll system is tracking things. You want to work with, your payroll, paychecks, ADP, whoever you work with, making sure we're kind of carving that out and able to not only do the accruals, but also track it so there is no abuse and things like that. FMLA, PFL, all those things we got to worry about here as well. Did a couple more questions come in?
Yeah, there's one more. It's kind of an extension, I think, to the question that was asked before. But does this time off for the sick time, does it have to be tagged as sick time, or can it be PTO? And if you already offer paid time off, do we have to give an additional 40 hours?
Yeah, so I mean, the way that I read that now is if you're accruing or offering the same or better perks or better benefits than at the state, you should be okay. I mean, if you've got a PTO policy in place, I would probably put in parentheses New York State, per New York State guidelines in your policy, or per New York State sick leave guidelines in your policy. You should be fine. The way I read the law right now, if you're already offering something like that, and it's a little bit, it's at least as good as what New York State's offering or requiring you to offer or better, there should be no add-on at this point, the way that I read it. But again, wait for more of that legislation to shake loose before we start to jump in and say yes or no to that. But right now, at a higher 30,000-foot view, the answer is yeah, you should be fine. The way that I've read it and done my research, but give it a couple more months for some of that legislation and some of those Q&As to start popping up on the websites as well. So, all right. Anything else come up on that one, Ed, that I need to answer really quickly? Or all right, good. So again, just another one here, coronavirus. I think that under the New York State, when that does take you to the recommended posting for coronavirus COVID-19, you don't have to put that up. It was a recommendation by the state. Totally up to you on that one. PFL COVID-19, just additional information out there as well on that one. But for the sick leave stuff, again, I'm happy to present again for this group, or even with that again, maybe, midsummer when we have more information on this, what that might look like. We can put together, add on to this presentation and continue on kind of building in what we should be doing as, as organizations are being much more proactive with this. And again, we could see this get kicked out into, June or July of next year because of some of the issues we're dealing with now. I don't know. I mean, again, I don't want to predict what the state's going to do, but it might be nice to kind of phase this in versus making everyone do it 2021. We've already got tremendous changes coming up in 2021. PFL goes to 67%, 12 weeks. You got your administrative and executive exemption jumping up to a higher level. Your minimum wage jumps up again. So those are things that are already happening on top of what we're looking at here. So the voting law, again, just kind of reinforcing this so people know about it. Just so we know, decreasing the amount of paid voting leave to 2 hours for employees to vote in any election, requiring the paid voting leave to only be available only for employees who do not have sufficient time outside of their working hours to vote. That to me is almost impossible at this point, unless you've got people working 16 hours a day. I think we're doing mail-in voting now in this state anyway, but boy, that one is going to be hard for anyone to sell that they don't have any time to go and vote. The last cases I knew about of any type of voter discrimination were from like the 1940s. I don't know why there was such a push to get voting laws updated in this state, because we haven't had any issues, at least from the 1940s or 50s. We're talking 70, 80 years ago at this point. So then again, just a couple other things. Reinstalling the presumption an employee has sufficient time outside their working hours to vote if the employee has 4 consecutive hours between shifts and opening and closing. So there you go. Then reinstalling the strict time frame for an employee to request paid voting leave to between 2 and 10 days prior to the election. So with that, we still have to have the old post, the pre-2019 poster up when it is time to vote in the workplace. Make sure that's communicated as well. And for that one, if people are unclear on that one, so am I. I haven't seen the state come up with anything yet on their website. If you type in New York State voting poster, it comes up with the post 2019 poster. Don't use that one. I'm still waiting to see when that new one comes out. I haven't seen anything yet with the older PDF or the updated 2020 PDF. So yeah, so that one is still up in the air on when they're going to release the poster on that one, or at least a PDF to post in the workplace. So I don't have that one available yet. I'm still kind of waiting to see on that one. I've talked to some attorneys and they said the same thing. They haven't seen anything recently either. So, all right. So with that one, I think I'm going to get into the compliance and, the audit really quickly. One thing I just wanted to bring to your attention in this presentation with this, I know we're kind of running over, but that's fine. I think we've had a pretty good discussion so far. I did include information. I've done some webinars on how to fight unemployment claims. So the rest of the slides really from 22 all the way down to I would say all the way down to, I don't know, 50, maybe 50, let's see, 56. It talks about what to do when you are going to fight an unemployment claim. So I'm just going to, again, give that to people. I'm happy to answer any questions offline if there are people that need help doing anything related to unemployment or how to manage that process. And then again, what does it look like to file for unemployment? This is just information. If you do have employees that need to file for unemployment, and maybe to make you aware what the process looks like as well, just again, some additional information. I work with a consultant in New York City kind of putting this together for her and I and our clients or just to communicate. So that, again, that's just additional information at the back of this thing. So you understand what that process might look like. So again, that's all yours to keep. So, all right. So let's see, I'm going to do a new share and pull up the audit document here. Let me see if I can zoom in a little bit on this, no pun intended. So this was the audit we did in March of 2020, actually right before we all kind of got quarantined, right? It was like literally a couple of days before this actually all went down because we never finished the I-9 piece. So
I think you and I had the last physical handshake in the state of New York.
yeah, probably. You're absolutely right. It was like a day or two after that, everything, because I was ready to come in the next week and sign the I-9s, and then it was like, nope, we got to wait on everything. So you're absolutely right. We got the handbook done. I got the audit stuff done on site, and then it was like, then everything was like, boom, everything's done at that point. So, all right. So again, just kind of walking through this, I'm going to go through it a little bit quicker, but again, it was conducted by me March 16th. So, if we do an audit for any of your organizations, it would be a very similar process here to what we did. Went through the applications. Again, Ed wasn't using an employment application at the time, doing more resumes, so I sent him a draft template to use if you wanted to. That's fine. Background check information as well. We could have reviewed that. That's something, again, he and I are going to talk about in the future when he goes to hire more people. And again, if he wants me to put together some interview templates or interview, guidelines, I'm happy to do that with questions as well. Offer letters and employment contracts. Again, I sent him a template to use, kind of outlining what's required on the wage theft notification form that we're supposed to give to people when we hire somebody, when we give somebody a promotion or change hours, or when we demote somebody as well. We're supposed to give that to them during that process. If it's a COLA adjustment, cost of living, whatever that might look like, I gave them the template to use versus using the state form and ensuring that we had all that up to date. I prefer the offer letter template that I have because it talks about employment at will. You're an employee at will. I really try to reinforce that in everything I do at this point as well, related to handbook language, sexual harassment policy, the telecommuting policy that we should all be using now, ensuring that people know what the expectations are on telecommuting. I really do add employment at will language and all that. So anyway, the template was sent to him. Just additional information on the 1099 stuff. The last time the W-9 was updated was late 2018, making sure he had that on file. And again, I sent mine over to him as well. The employment handbook and policy and procedures, I think we completed that, or we're pretty close to being done with that as well. Again, we wrote that. He sent it to me. I revised it, tweaked it to what I thought would be good, and then ensured that we were, on par with that one. So that's all set on. And I mean, Ed can speak on that if he wants real quick. Jump in on that because I'm going to do a quick search on the state website on posters. So if you want to comment on the handbook, go ahead and do that. So.
Well, I guess the long and the short of it is, I think every employer that's out there, myself included, knows the value of having a handbook, and also knows the reality that we all live in today and that we all hire people in today is that everything that we use, everything that is employee facing, has to be treated it has to be viewed under the lens that it could be used as a piece of evidence, yep, either in a hearing or in a legal proceeding. And knock on wood, I've never had to terminate an employee for cause. I've had very, very long employee histories with people, and all that's very good, but you just never know. So going through this process and being forced to take a really hard look at everything was some of the best time that I've spent. And that was what really started the gears turning for me about trying to put something like this together, because we're all busy. And like I said in the very beginning, a lot of my employer groups that I work with are a lot like mine, and they're small. They don't have a dedicated HR person on staff. There are some that do, some that are on the call today. But it's always good to get a second set of eyes and to have somebody on the team. So that's where all this got started. So I'm glad to say that I feel pretty compliant, and I'm pretty sure I won't be put in an orange jumpsuit and dragged out of my office anytime soon.
Yeah, I mean,
DOL violations.
Yeah, I mean, and it's really the fines continue to go up on all this stuff as well. So, I mean, he's absolutely correct. I mean, it's just the compliance side of HR has gotten so complex that if you're not really understanding, kind of the ramifications on this, or what to look for in the audit, or what to look for in the handbook, it can be very overwhelming to people. I mean, just going out and searching employee handbook, you could get something in California or Minnesota that's completely illegal in New York State. It's not going to fly, and you don't want to do those things. So he's absolutely correct. So if you look on here, I just wanted to show you, I did New York State labor and employment law posters. So posting requirements, New York State. You can go on here, you pull up all these things. It will take you right to the posting on this website, and you can get all that information on there. For all the posters, it will pull up the federal stuff as well. So easy enough to see some of these things. Again, some other things, your disability, workers' comp, unemployment. Again, and that was one I think we did not have, was the unemployment poster for Ed at the time. So that was one of the ones we found and flagged and made sure we corrected. And again, I will tell you, you can print out all these required postings here. I know you can't really see this back here. You can get all this stuff online for free if you want. That's up to you. That is all on the federal and state websites. What I've discussed with my business partner with this, anyone that's working with Ed on this, I'm happy to do 10% off a poster as well. We print them right in Corning, New York. I can hand deliver them if you're interested in that, but I am happy to answer any questions on posters or make sure you are compliant. Because normally when I go in, there's an issue with handbooks. There's an issue with the wage notification forms or the offer letter. There's an issue with the labor postings as well, issue with I-9s. Those are some common ones that I see in my audits. In fact, it's 100% common because I've had 100% issues on all those things. So anyway, so review posters, we did that. Recommend 2020. Again, 2021 minimum wage goes up again. Division of Human Rights language went up or changed as well with the hairstyle and some other things on pay equity. So that was another one that got changed. Again, we'll have sick leave potentially. So these are a couple things we did see as part of the audit. No unemployment posting. Again, we talked about that. The workers' comp had an expiration date on it. That was out there. And then no voter posting. We do need to change that one as well because that went back to the old 2019. And I'll take care of that one for you. But that is one we would have to change. So, and then again, I send you a list of all these things to take a look at, posters, all the information out there for you to go and do all these things on your own if you want, or you can contact my company as well. Easy enough to do this. OSHA 300A, something you want to take a look at. If it's office work, normally you could be exempted based on your organization where you don't have to post an OSHA 300A log or OSHA log. That's something we'd have to determine case by case for every organization, but that is one we wanted to take a look at as well. So OSHA, again, just more information on OSHA here. The employee benefit documentation, that's really Ed's, this is all in Ed's wheelhouse if we're looking at baseball analogy here. So I'm assuming no one has any issues with the general notice of COBRA, so I'm going to skip right over this thing and make sure. But again, these are common things I will find with organizations that, besides, Ed specifically, that are not doing these things and not providing this information. So that's why this template is in there as well, just to have it in there so you've got it and understand what is required. So your I-9s, this is another one where I can tell you every time I've done an audit in this area or even across the country when I've done some remote stuff, guaranteed audits or guaranteed mistakes. So what we did again was take a look at the Form I-9, making sure he did the right thing where we had some mistakes. And again, Ed, just again, not to beat up on him at all during this presentation, but he is taking a payroll off of his business. So legally, he should have an I-9 for himself showing that he is legal to work in this country. Most people don't know that, is that the owner of the business, if you're taking payroll and being paid through payroll, you legally have to have an I-9 on file. And so that's actually one we do have to finish up with him as well as part of that process. So again, just what I put in here is just kind of how to correct them, how long we retain these things if you've got people that quit, what the process might look like, any of the revision dates that we have, recommendations that we need to do. I mean, very straightforward. Some of the Q&A stuff you might have questions on, anything. And again, I'm happy to walk through anything that we've got. The correction letter that we need to put with some of the corrections we've done and sign off on. Again, I'll be signing off on his to verify as an acting member of the organization that I looked at his IDs and verify that he was legal to work in the country. But it's important to get all these things done because the fines on I-9s can be extensive, especially if you have 100, 150 employees. It's normally the way they calculate fines is by error. And so if you've got 7 errors on one form and you've got 100 employees with 7 errors on each form, that's an issue. That can be extremely expensive. And I mean, here's a couple examples right here, right? So event planning company, let's see, ended up costing them big. The company neglected to ensure that Section 2 of the I-9 included each employee's signature with additional incompletions, 800 violations, a total of over $500,000 in fines for an I-9 violation. National staffing company, wrong person signing for its remote workers, $250,000. A construction company that wasn't really doing anything, another $250,000 fine. The government's laxed the rules a little bit on this one where they've allowed more people to sign off, but we can have that conversation separately related to who should sign off on that. This is what the form should look like, right? So I kind of gave you some walkthroughs on this. I'm happy to provide any of that. We might take a look at payroll if there's any issues there. Happy to take a look at the payroll stuff. And then the wage notification forms, I put links out there for everyone. The one thing I have noticed with the wage notification forms and other audits is people are doing them, but they're using forms that are old and they're outdated. So the most recent form that New York State updated was 2017. I've seen people using stuff from 2011. I think 2013 might have been another year they changed it. So just be aware of that. And kind of jumping back into the I-9 as well. The new form was effective, I believe, May 1st for the Form I-9. So just be aware of that. Again, I've seen people using forms in 2018 from 1998. That's not going to fly. I mean, that's an issue. We're going to have to correct that as well. Just want to be aware of that as another issue, making sure you're using the right forms as part of the process. And then, again, the W-4 form changed quite significantly. The tax forms, the IT-2104 is another one. I have audited organizations in this area where they don't use the state tax form and they just have people like write next to the federal one on the form what they want deductions on the state one. It was really kind of a weird thing I've seen. And I've seen that in 2 or 3 organizations, not just one. So just, again, making sure we're using the updated forms. We have state and federal forms on file related to that. And again, if you're working in a city like New York, you have employees in New York City, there might be a separate local form as well. When I worked in Cincinnati, there was a 3rd form I had to fill out there. So just be aware of that as well. I'll look through the personnel files and flag anything that we've got there. Again, record keeping and training, EEO1. Again, that got bumped again anyway. But again, these are things just to look at as well, just making sure that you're doing the same thing. And these are just Q&A here on whether you need to fill it out or not. But that's another one to take a look at. Performance reviews, if we need to take a look at that. If there's anything I can recommend on performance reviews, happy to send over some of my templates and things like that to look at. Training records, again, we want to make sure we're keeping track of the sexual harassment. I think I gave Ed, I'm happy to provide anybody the quiz I used during my sexual harassment training. Remember, that's an annual thing. You want to have the policy in place. You want to have the policy updated to say 3 years versus 1 with the Division of Human Rights claim. Signature would be good for that as well. And then again, these are just some things to think about with the sexual harassment. I think here is at the end. And then I just summarize it, kind of put together action item list. If we've got job descriptions, if there's independent contractor agreements, anything like that, we need to take a look at. We absolutely can. And again, I think updated sexual harassment policy. We did add the complaint form, and then I sent the quiz along as well. And again, sending any researchers from the state side. So then just, again, the follow-up items we had to take care of. You can see here is kind of what that looks like. And we work, hand in hand in making sure that gets done. And then I send you this document to have as part of your audit. And then if we've got questions on any follow-up, that's what the process looks like. It's fairly easy, fairly efficient. I mean, again, if you've got 150 employees, it's going to take a little bit longer than what Ed had. But normally I'll just create a list. I mean, if there's specific issues with employees related to the I-9 or whatever that might look like, I'll generate a list of what those employees look like. So I can tell you, I did one earlier this year, or excuse me, it was late. It was right after Christmas I did this one. And it was a group nonprofit with 150 employees. I would probably say I found 90 to 99%, if not 100% issues with their I-9 compliance. FMLA was an issue. And again, part of the process with that organization was managing the HR person out and replacing, and being on the phone with the attorney. Again, I wanted a second look on the exit process. he was shocked about how bad the audit was. I mean, he's like, I've never seen anything like this. And so again, I'm pretty meticulous when it comes to these audits. My job is to make sure we're doing everything as proactive as we can, and making sure if something does end up being reviewed by the Department of Labor or ICE or USCIS related to some of this stuff, we're ready to go and ready to defend anything we've that you've had and that we've corrected. So with I-9s, you can have 3 different agencies audit those things, which is an issue, right? So we want to make sure that we are being as preventative and proactive as we possibly can. So that's really all I had today. I know we kind of went over. We had it scheduled for 1:30, so I think we're good on time. I didn't think we were going to go more than an hour, but it's been great to kind of walk through this as well as we have. So again, I appreciate everyone's time, and I'm happy to answer any questions or work with anyone as well on any of these issues. So happy to take any questions or answer anything with the remaining time. Thank you.
Yes, thanks for all of that. This is definitely a lot of information, and I know that I can speak for myself in just saying that the information that you gain from going through an audit like this, from going through a Q&A session about files and employee relationships and all of these things. Everybody that was on this call, and I think I can speak for every client group that I work with, they don't ever do anything with an intention for there to be a problem. But there are so many moving parts there, and especially now in the last few months with what has gone on, these compliance points have become even more important. And I think that it would behoove everybody to take the time to reach out to you. You can certainly reach out to me, ask questions, and we can coordinate that. But while we have the opportunity to make sure that our systems, our processes, and our protocols are in place, is going to be important, because the reality is that regulations never get lighter over time, and especially in a state like New York, we are always going to have more and more that we have to be concerned about. So for anybody that, like I say, that has questions, make sure that for now, jot down Matt's email and his phone number, and be sure to reach out to him if you have questions specific to me. More than glad to answer those. Emails a great way to get a hold of me as well. But we just want to make sure that everybody's got good information to work forward on. Some of this, as you said, Matt, is fluid. It's going to be changing over time. But the important thing is to form that relationship now. Take the time, do the reviews, dig in a little bit deeper. And the worst thing that can happen is that you find out that we're doing everything really, really well. We just have to make a couple of small changes. That's really the ultimate good answer to get. But if you find some things that are really wrong, this is a great way to find them, fix them, and make sure that they're not going to be a problem going forward.
Absolutely. Yeah. And I'm happy to, again, as we see some changes to the New York State sick leave, or if we see any updates to the paid family leave, I'm happy to do another kind of like lunch and learn, another one in a couple months as we get closer to some of that rollout or what that might look like. That's not an issue. I mean, I love to be able to present this information to people to ensure that you are making the best decisions for your employees, but also for the longevity of your organizations as well. And, ensuring that we are legally compliant, because it is a very complex state to do business in, and the laws continue to evolve almost daily. I mean, and I'm not joking, they change almost daily in this state. So it is a challenge to keep up on at times. But again, I've got a network of people that I rely on to ensure that we are giving you updated information. And I spend a lot of time researching and writing on this stuff as well. So happy to include anyone on my monthly or weekly emails as well. I try to create articles every week. You can go right on my website and put in your email. That goes to my marketing person, and you'll get my distribution weekly. It usually comes out Monday morning, so that's not an issue as well. And I can work with Ed on that to ensure people do have that information. I will send out some of those poster websites. Once we get off the call, I can send those over to Ed to distribute to this group as well. So again, thank you very much for your time. I appreciate it.
All right. Thanks so much. Like I said before, any questions, be sure to send those to me or to Matt, and we'll go from there. And I'll look forward to touching base with a handful of you offline as well. But for now, we'll end the meeting, everybody. Have a great day.
Yeah, thank you very much. Have a nice day.
You got it.